hosting this press conference this afternoon. May I start by introducing the panel? Journalists from 8 media houses in front of you, including our own. To my left, I have Mr. Mbulaheni Maghuve, who's acting group for human capital for HR. Next is Mr. Mbulaheni, who's group executive for corporate affairs. To his left is Mr. James Aguma, acting CEO, and our chair, Prof Maghuve. And the two judgmen at the end of the table are Lucky Tekisho, who's attending to the Prof, and Sizwe Velagazi, our own head of legal services. Colleagues, the chair has called this press briefing this afternoon to talk about the inquiry in Parliament that's currently underway. I'm going to hand over to him to address you. After him, Mr. Aguma will talk to you, followed by Mr. Lipaka, and then, Mr. Mtsoneng, then Mr. Lipaka. And the two lawyers at the end will speak thereafter. Over to you, Prof.
Thank you, and good afternoon. As you heard from the program director, the inquiry on the fitness of the board has commenced this morning. Before the commencement, it was deliberated whether the inquiry itself should commence or not, because we have appealed the judgment of Judge Desai, but I will leave that in the hands of the lawyers to address the appeal itself. I must also hasten to indicate that, truly speaking, I'm not against the inquiry taking place as it is purported out there. No. The interdict that we had a week or so ago was that I believed that the process was not going to be fair, independent, and impartial. Then the attitude that prevailed today, as the inquiry was commencing, was very, very negative or hostile. As the chairperson, I felt bullied, I felt belittled, I felt disrespected. The utterances made by various members of the ad hoc committee attest to what I've said. Further, I think, to what I've heard, this inquiry is a done deal. There were statements by various members saying that I should give reasons why I shouldn't be dismissed, because a decision was taken to dismiss me, or that they've got powers to dissolve the board according to the Broadcasting Act. and they must dissolve the board. Now, subjecting myself to an inquiry which is crystal clear that my rights are not going to be respected, I think serves no purpose. At times, members of the ad hoc committee express views that I'm there in my personal capacity and I will be held accountable for whatever. And if that doesn't suit them, I'm there as the chairperson. Now, I'm confused. In what capacity do they want me to avail myself? In my personal capacity or in my capacity as the chairperson? Because they even say the board doesn't correlate, therefore I don't have the authority to take decisions. Yet they say they want to compel me to provide documents. Which authority do I have if they say I don't have authority? The other thing that I want to also highlight is that yesterday we wrote them letters and we were raising pertinent issues. The notice that I received from the chairperson of the ad hoc committee categorically stated that I am entitled to 4 things, and I'm going to mention them. First, I'm entitled to legal representation. My legal team requested them to address them for a few minutes. Initially, I thought the chairperson was about to grant my legal team the opportunity to address them, but he later changed his mind. Second, I'm entitled to documents. To date, the only documents that I've received is the notice for this inquiry and the program. And when we wanted to raise these issues, I'm told that documents are readily available on the internet. Yet, members of the ad hoc committee were having hard copies of those documents. And I also believe it is the duty of the ad hoc committee to make documents available and accessible in a format preferred by myself. I've never had a situation where you are told that you must appear before an inquiry and you must prepare your own documents. Besides the preparation of documents, as we speak, the AG made a presentation. ICASA will be making a presentation if it is not making it now, and the public protector. Even if I had Braille documents, we are talking about big documents. For those who don't know how Braille is quite bulky. One print page could be 2.5 Braille pages. Now, does this committee believe that I should carry bags and bags of documents, some of them not going to help my cause? But it would have been fair to say the presentation of the AG will touch on these sections so that then I know which document to carry, instead of just carrying documents and documents and believing that one of them will be useful. Second, the inquiry has commenced, as I've said. And I was also told that I've got the right to witness statements. I don't have those statements as we speak. And when we wanted to raise this matter, it was said they will consider to give us in Braille, but they don't even know how long it will take for the documents to be ready. Now, how do I prepare myself without these statements? How do I prepare myself without presentations by various structures and individuals? And the chairman even said something which I felt it was not right, that someone would be a scribe and will take notes. If you take notes that make sense to you. You don't just write. Now, how will that scribe know what will be sensible to me? Or will that scribe just write everything? And when would we have time to read those notes and prepare? If I am to appear tomorrow. They further said, I've got the right to cross-examine witnesses. But late last night, as I was listening to the news, the chairperson was interviewed and he said, I may attend the inquiry if I want to, but I will not be allowed to cross-examine witnesses. But in his letter addressed to me, he said, I'm entitled to that. Now, if fairness should prevail, independence should prevail, and so on and so forth, why can't I cross-examine witnesses? Does it mean, no, actually to me, and I want to emphasize this, I'm saying to me, it means that the committee is saying the witnesses are the only people who would be telling the truth. Hence, there's no need to cross-examine them. Now, I feel that my rights, are, my constitutional rights, are being violated. The right to legal representation, the right to information, the right to cross-examining witnesses and so forth, on and so forth. And by the way, the UN Convention on the Rights of Persons with Disability, Article 12, 2 and 3 and 13, talks to these rights. And I think it is not deviating from what our Constitution is saying. But that as well, I will leave it in the hands of the attorney. He will address that as he makes his comments. I'm not happy with how things are unfolding. Really, I'm not happy. And I still maintain the view that this process is not fair. If already a decision is taken to dismiss me, and I also don't believe that the process is fair if, when it suits them, I appear in my personal capacity, and when it doesn't suit them, I appear as the chair of the SABC Board. That is what I wanted to put to you, because the public out there believes that I am stalling the process. As the ad hoc committee is saying, I'm not stalling the process. I need documents, and it's my right. I need to be respected. I don't have to be bullied. These are the people who should lead by example. Not to bully, not to disrespect, not to belittle, and not to intimidate. Thank you.
Thank you very much. I'm going to deal with the issue of documents that the Portfolio Committee has asked for. And my focus is going to be, not the Portfolio Committee, sorry, the Ad Hoc Committee that the chairperson has talked to. And I'm going to focus basically on the documents that we believe that if we release to the Ad Hoc Committee, then the commercial interests of the SABC will be affected. And here we need to state that the SABC is unique in the following sense, that it's a public broadcaster, but we have revenue streams of up to 85% of our revenue streams are from commercial sources. And we're talking about advertising and sponsorship revenue. So 85%, if you go to our annual report, that's what it is. And about 13% of our total revenue is from TV licenses. Then 2% thereabouts is from government grants and other sources. So in effect, the majority of our revenue is from commercial sources. So that implies that we have commercial agreements with our clients at different levels, which agreements therefore result in the revenues that we are talking about. And included in some of these agreements are confidentiality clauses, wherein a client says, I'm going to engage with you at this level and give you X millions or X hundreds of millions for advertising on the condition that you keep this confidential. So these are the concerns of the SABC. And some of these agreements are also discussed at the board level because we have a delegation of authority framework that says certain limits of deals will be approved by the board and so on. Now the challenge we have here, and I need to state it categorically, that the SABC and the members of the board and the executive of the SABC respect Parliament. There's no doubt that we do respect Parliament because we are Schedule 2 entity. We are aware that we are listed as such in the PFMA. But at the same time, we also have as an executive director of the board and the chairperson as a non-executive, we have a duty to safeguard the interests of the organization. Insofar as ventilating of some of these documents is going to affect the commercial interests that we have as the SABC. We are very aware that if we hold, if we're a media company of which 85% of our revenue is from advertising, it means naturally that we have competition. And some of you in this room represent media houses, whether it's print, whether it's broadcast, you represent those media houses, and you also have an interest in advertising revenue. So we're saying, as the SABC, that it's going to be very, very difficult for us to provide these documents, absolutely difficult if we know that we have agreements with our counterparties that make confidentiality something that is paramount. We're also aware that a lot of our documents at the SABC get leaked to the press without authority. And we're not saying that the committee is going to do that, but we are aware that these documents are out there in the press, not all of them. So we're saying that we are very, very hesitant, and we are robust in this sense that these documents that we believe are going to have, are going to be injurious to the interests of the SABC, we will do our utmost best to prevent them being ventilated there. There are some of them that we necessarily find strange that have not been provided to the portfolio committee, rather the ad hoc committee. One of which is, like, for example, the skills audit report. I'm sure that there was a presentation made to the parliamentary body. I think it was the portfolio committee. That is there. Another document that they were asking for is an internal audit committee document. We're not aware of such a committee, internal audit committee. We're aware of the audit committee, but internal audit committee, we don't have such a committee at the SABC. So it's such issues that we would like to really deal with. But be that as it may, we still hold the view that some of the deliberations there around business deals, around structure changes, and so on, are confidential and would like to keep them as such. We've also had this trend of thought that says, no, we are shareholders, therefore shareholders of a public broadcaster, therefore all these documents should be in the public realm. And we have a different view. We're saying, right, you're shareholders, but in any public company, or even private, shareholders appoint directors. And then the directors run the activities of that company. But if the directors are telling you that on behalf of you shareholders, there are certain documents that we would prefer not to ventilate in the public space because they contain confidential information, and the shareholders are saying, no, bring them out to the public, then we find that very strange, because out there is also competition that I'm sure would be very happy to learn the business and other secrets of the SABC, what we would loosely call decisions that give us the competitive advantage to the extent possible. It's as good as a mining company, and I'll just pick one off my head, let's say Goldfields, says that we have now developed a new mining technique that would probably halve the cost of mining gold. And the shareholders say, no, you got to ventilate that in the public because we're shareholders. Of course, no company is going to bring its secrets and confidential information in public, especially if it's injurious to the interests, to its commercial interests. There's a need also that we need to give the committee a report of the SABC that deals with the AG's findings. We need to state the following, that the SABC in 2013 had a disclaimer. That is, it had 9 qualification paragraphs. An action plan was written to deal with each of those 9 qualification paragraphs that in total gave and the SABC a disclaimer. That action plan was presented to the shareholders, the minister, and also shared with the portfolio committee. It hasn't changed. We have worked at it industriously. And from 2013, where we had 9 qualification paragraphs, we are now sitting at 2016, year-end 31st March 2016, with 1 qualification paragraph in irregular, fruitless, and wasteful. But we still asked, give us the action plan to deal with the findings. And we're saying, but there's only 1 remaining. So I believe that the SABC has shared this action plan with the committee. I know I did that in 2013. It hasn't changed. It may not be with the ad hoc committee, but it's in the parliamentary process, definitely in Parliament somewhere. So we are remaining with 1 qualification, which ordinarily we should have actually dealt with, if not of internal issues. But we are working on that. So our only qualification that we have at the SABC on our financials is relating to a note on irregular, fruitless, and wasteful expenditure, which we are dealing with. So from 9 paragraphs in 2013 that led to a disclaimed audit opinion, we have slowly worked down to 8 in 2014, to 3 in 15, to 1 in 16. So we are willing to cooperate with the committee in as far as giving of documents are concerned. But those that we feel that are going to have a negative effect on the SABC, it's going to be very, very difficult. And I think it's our duty as directors to make sure that we do not ventilate documents that we feel are going to, I mean in the public, that we feel are going to affect the competitive advantage of the SABC. The committee should be aware, and I'm sure they know, that the advertising cake is of a certain size. The SABC has its share. Everybody else is interested in getting a piece of it. We're also very aware, as part of our research, about the declining circulation of print media. We're aware of that. And when we do our reviews, we see that SABC tends to be attacked in that area of the print media. So we don't know whether it's real or it's part of the competition around advertising. But that's for them to decide. We are not bothered about what drives them. And here I'm talking about the print media. But all we are saying is that we find it problematic to share confidential information with the ad hoc committee, especially if we don't have guarantees that that information is going to be kept confidential. Thank you.
Thank you very much. We as SABC, we have a duty to fulfill. We are here to make sure that we defend the organization, whether forces are all out there to destroy the organization. Because we have been observing that there are many forces having different interest on the SABC. We are aware of that. We are also aware that SABC, for the first time, has done very well financially on governance matters. We are aware that people are not happy, some of them, when they see that every day SABC is growing. Every day, SABC is doing wonderful. We are also aware that there are politics here that we need to deal with, and we're not going to be apologetic when it comes to the agenda of certain individuals putting their own agenda, abusing the same process of Parliament to deal with the SABC. Because if you take issues very seriously, I don't see any reasonable person saying that I'm going to investigate SABC. As James has already alluded to the issue of disclaimer from the organization, when the organization is on track and you only have one qualifications, you are saying now we are doing investigation because the SABC is collapsing. There is no way that SABC will collapse under our watch. We want to emphasize this. Previously, SABC, we know that there were many historical issues. We have dealt with those issues that are historically, but I'm also amazed that people who are called there, some of them are opposition to the SABC. There are opposition people who are fighting for the SABC to collapse, and you want them to talk about governance. What they know about the SABC governance? when they are outside SABC, because SABC should deal with governance issues. SOS, I don't know who they represent. I'm amazed that they are there. I also hear there are some parties that are going to be invited or they have been invited. I don't know what informs that, because the fact of the matter, we are competing with other media houses. The fact of the matter is, we as SABC, we are not getting funding from government. I want to emphasize, we are not getting any funding from government. The only funding that we are receiving from government is less than 3%, which is grants. And let me explain grants. Is for educational programs, is for digital migration. SABC rely more on commercial. I want to emphasize the taxpayers issue. People are making all this hullabaloo. SABC is misusing taxpayers' money. Which taxpayers' money people are referring to? Because if people read the SARS, because we account to SARS when it comes to tax. You know, when you pay TV license, you are paying for your service. It is not the taxpayers' money. You can go there and confirm with SARS. They will tell you it is not a taxpayers' money. So people have been misleading the public about SABC misusing taxpayers' money, when reality is SABC depend on commercial. Yes, it is true that the Broadcasting Act deals with the issue of the public broadcaster and the way public broadcaster should handle issues within public. We are in agreement with that. We are in agreement with the constitution of this country, where it says Parliament, they need to oversee, especially the portfolio committee, oversee the SABC. But we are also saying, you know, if we are not getting funding from Parliament or from government, we get funding from commercial. And I have been alluding to this issue to say, how do we open our books when the funding is coming from left, is not coming from right? How do we open our books? Because the danger here is a huge implication. We reveal our finances and our partners today. I can tell you, tomorrow SABC will collapse. SABC financially will collapse. People will lose jobs in this country, which we are not prepared to play. We are not saying we're going to cooperate with ad hoc committee. I'm on record to say when the noise comes, we should face the noise. And I'm ready to face the noise. The SABC is ready to face that noise. But this noise, we need to be very critical when it comes to the SABC, because we rely more on commercial people who are funding SABC. It's not government. If SABC, they were contributing 100% funding the SABC, what will be the reason for SABC to say we can't give you all information? There will be no reason. What they need to do is to fund SABC so that they don't have these issues that we are saying. Some of the documents we can't give you because there are clauses when we do this partnership. And let me tell you, we don't have relationship with multi-choice only. We have many business relationship with many business companies. Immediately you reveal all the information, you are doomed. So we have a duty to protect the organization. And I want to emphasize, when you read the Broadcasting Act, it's clear SABC should use other means to get funding. SABC, we are using other means to get funding. That means that we are using now is we partner with big companies to make sure that they contribute to the SABC and financials of the SABC. So those clauses prevent us to give that information to the third party. We are willing to cooperate. We are willing to make sure that we go and defend the organization as SABC. But also it is very shocking that people of South Africa, some of them, how do you question 90%? When 90% empowers South Africans and Africans. The same parliament applauded the SABC. Well done, SABC, about local content. After well done, now you have investigation dealing with the same people who applaud SABC. Now I'm saying this is politics. And if you have been observing in that committee, someone came in, was willing, but this is my personal view, I may be wrong, the chairman was willing to give the chairperson an opportunity to deal with the issues that he was concerned through his legal team. But someone came, the mood change, body language change. I realized, hey, here is politics here. We are dealing with a different issue here. We are not dealing with real issues. But no one is above the law. All people need to be respected. I did also engage some of the members of that ad hoc committee because I was not happy the way they have been dealing with the chairperson. For some of us, we don't have a problem. If you have drama, I also hit back with drama. I don't have a problem. But in this case, we need to respect people with disability. We must respect that. The way we treat other people, I don't think we can use the same methods to treat the chairperson of the board. I think it was uncalled for some of the comments, and I confront some of those people. It is not a secret. I raised my own concern. I said, here you need to understand you are dealing with someone different. And I'm not saying chairperson is different, he can't be asked tough questions, but the way people deal with people with disability, they need to be very careful. We all have the rights in this country, including the portfolio committee, including the ad hoc committee. When they deal with issues, the sensitivity, Ubuntu should be there. This is what we are saying as SABC. But we as SABC, I can't be part of collapsing the organization financially and making sure that we reveal all the information, and that information, now we are supposed to retrench the staff of the SABC because it is reality. We reveal all this information. What is going to happen? Who pays the staff of the SABC? We get money from commercial. It's not from government. We need to emphasize these issues so that when you write about the stories, you know what is happening. I have been observing when people make noise about, no, don't pay TV license. Don't pay TV license. Don't advertise on the SABC. And I have been saying to the SABC people, actually, they are saying SABC should retrench you. That is the message that all these people who are making noise, and some of SABC internally, they clap hands, not knowing the implication is to retrench them. When investors, they don't invest in the SABC. We must protect that organization. But we must protect SABC from politics. We must be independent as a public broadcaster, no influence from any political party. That one we will defend it. 9010, I will defend 9010 in my grave. That one I will do, unapologetic. We must defend what is good for South Africans. We must defend what we believe as SABC. We are making sure that we empower our own people in South Africa. The whole continent, they are very excited about SABC. The whole continent, some of them, they are using SABC as their own benchmark when it comes to local content. Now here is the investigation, investigating the same issue about what we are supposed to do as South Africans. I want to repeat myself. You know, the world can change. I will never change my conscience when I know I'm correct. Even if I'm alone, you can say, hey, Cloud is mad. Good madness for this country. And that is what we are going to do as SABC. And it is very important that some of the matters that people are dealing with in that ad hoc committee, they are court matters. They are in front of the court as we are speaking. So we need to be very careful about issues that are in front of the court when we are saying we respect courts. If the matters are in court, those matters, the court should deal with the matters until the court finalize everything. I believe some of the information, they are court matters. We are dealing with all those issues in court. But also, it's amazing to realize that some of us were not called by the same ad hoc committee. When my name is all over, in due process, I'll be consulting my legal team to deal with these issues, to say, but how can my name be all over? I'm not invited to deal with the issues in the committee. We as SABC, we even ask to be part of that ad hoc committee so that we can explain the issue affecting the SABC and protect this wonderful organization and protect the employees of the SABC so that they keep their employment within the organization. The acting GCO was dealing with the issue about media. I'm concerned about this hullabaloo and media playing the role of misleading the country, because that is the agenda of media, and that is the agenda of some of political parties to destroy the SABC, when SABC actually is doing very well. And we are saying this is the opportunity for SABC to clarify issues. I'm very happy about the ad hoc committee, but my unhappiness is when I don't see fairness, because we need to see fairness when people deal with these issues at the SABC, because you want to go there and deal with the issues, because for us, we don't have any secrets to hide within the organization. What we have, we are just saying part of commercial, where we know we are going to harm the organization. We are going to collapse the organization. I'm also aware that many people are being retrenched at some certain media houses. We don't hear about them. But at the SABC, good story to tell is we are not going to retrench anyone at the SABC. That is good story to tell. The only problem that can face the SABC is when we reveal all our information to the third party. And in this case, if we are clear about the process of Parliament or portfolio committee or ad hoc committee that they will protect information, I don't see any reason why can't we give them information in confidence, as long as we are sure that information will stay there. But you know, some of them, and they have been doing this, we will say these issues are confidential. They will go and release press statement, you know, playing the game, trying to attract media attention. We are aware of that. So, and we are concerned. The reason why we are saying we don't want to give certain information is because even people release press statement. Example, one party released that SABC, we are in trouble because we have lost more than 1 billion. And it was misleading. And you as media, you have been running with that statement when you knew yourself that we have clarified the statement to say it was 411 million. And 411 million, I'm still saying to you today, it is not a loss. It is investment for our own people who are suffering in this country, so that we empower them. Because if they are projects of national interest, that is where we put money. I have been observing people saying that we didn't pay needle time GCO. And I want to talk about not paying needle time. There are fights amongst artists themselves. And we as SABC, we have put budget aside to deal with needle time. And when we put that budget aside, we said we want to make sure before we pay, the artists, they get money. The families, the right people, they receive money. Those are discussions. The money is there, is sitting there, but we are waiting for all this collecting society to come together. And you are aware that there are so many of them, and they have different ways how they handle matters. But we as SABC, we have put budget, and we are only broadcaster who said, when the court said you pay from 2013, I think, CISO, if I'm correct, we said we are going to pay from 2006. That is wonderful for SABC. We are only broadcaster who says we are going to pay because we have been actually not doing the right thing to pay our own people royalties. The money is there. It's just that we are dealing with the issues to make sure that we distribute money to the relevant people. So there is no crisis. You know, we even pay 50,000 rands to appreciate for what the artist has done for this country. So people, for them, they think that if they deal with SABC, they are the heroes in this country. We believe SABC, we're heroes because we have justified our efforts to empower Africans. And I want to emphasize, when we talk about empowering people, we are not discriminating white people from that empowerment. They are part of that empowerment. Still need to be empowered. We need to prioritize them. But we still do business with white people, because some people, they were saying, hey, it seems as SABC has taken a view. No, it is a rainbow nation, and it is what we need as South Africans to make sure that we can. I think all of us, we should adhere to the Constitution. When we do what we do, we are exactly implementing what the Constitution is expecting from SABC. Example, we must cater for all 11 languages in South Africa, which, when we introduce 90%, is part of the Constitution, and we think that we are adhering to that Constitution, so that we as SABC, we play that role of the SABC. When it comes to equity, it comes to procurement the process, we believe we are within the Constitution to make sure that we empower those people, including people with disability, because we as SABC, we have already taken a view to say we need to make sure that when you produce content, you should not take Mhlolo and Mhlolo pretend as if he's someone with disability. we should make sure that we get people with disability to act themselves on television and radio. We should make sure that people with disability, they produce content. So it's part of a good story for SABC to tell. And you can't do that if financially you are not sound. So financially, SABC, we are good. What we are implementing now is because of all those good stories that we have been doing. And I want to add by saying that we respect the ad hoc committee, but we are saying people need to give SABC an opportunity to deal with sensitive issues. We are ready. We are not afraid to go there and deal with the issues. We will always stand and defend the organization when there is a need for SABC to be defended. And we are saying we are ready, and we respect that committee. I think the issue is maybe how people deal with the issues, because these are sensitive issues. But we are willing today or tomorrow to deal with the issues. But we want a fair process. Thank you.
Thank you, colleagues. Mine is just to clarify, probably if you're still in doubt of why did we take this action earlier on. People would have said we have walked out. Maybe we should put it more rightly to say that we were defending the rights of the chairperson of the SABC board. You will all know that those learned people, learned friends of mine who are here, there are issues or ways that are called sub judice, and you must now tell us if anything that is sub judice can still be discussed outside the courts of law. I'm leaving that to you. My colleagues here have already said that we do respect the ad hoc committee, we do respect the process of the inquiry, but we also say that there are acts that have been passed into law by the same parliamentarians that are members of this ad hoc committee. You have the Labor Relations Act, you have the Employment Equity Act, you have the Basic Conditions of Employment Act, and as far as we are concerned, and you will maybe agree or disagree with us, the rights of the chairperson of the SABC board were violated this morning. And we are saying we cannot allow that and be party to such violation of rights. Those cannot happen under our watch, and that is why we believe that it wouldn't be very fair to participate or let the chairperson of the board participate in a process that we believe that it is flawed, like the one that was flawed this morning. We believe that this sounded more like a kangaroo court than a fair inquiry. And I don't think we are in the space or in the age where we should be respecting kangaroo courts. What has happened in as far as from the HR point of view, we believe that the rights in as far as the inquiry of our chairperson were violated, and we're never going to be party to that. So the community must know that, the public must know that. By virtue of being here, it shows enough that we're respecting the process, but we believe that it should be a fair process. The process must be fair, and the procedure should be right. No one should be called to account or attend an inquiry if that particular person has not the necessary information that he can answer to. That is basically what informed our action earlier on. Thank you.
Thank you very much. Thank you very much. It's good that most of the legal issues has been ventilated by my Leonard friends here. And our advice would be for them to go and study law, because they spot on a number of issues that they have raised, especially Mr. Mutsuening. We want just to clarify some few things to say we are not against any inquiry. I think it must be made very clear. What our issue is that the process must be in line with the constitution of this country. That's our gripe. And we are of the view that up to now, it has not been. Now, we are further dismayed and shocked in the manner in which Professor Maghuve, who is our client, has been treated in Parliament by the ad hoc committee that appears to claim that they are holier than thou, which to us is a serious problem, because in what they have been doing, they've really violated his rights. And we'll be able to tell you why we're saying that. But also, the thing that shocked us even further was the fact that we have appealed. As you would know, when we have appealed, it follows that the process must stop until the matters has been resolved. But also in terms of the law, it's possible that they may be able to continue, but there are implications of that. But they've got a legal opinion that is very clear in terms of the approach that they need to take. And the legal opinion was saying that it's not advisable for them to continue up until they've dealt with the issue of the appeal. But to our surprise, they went there in the morning, they spoke about it, but they said as politicians, they will be able to continue. Now here is what we are saying. We are saying we have a constitution in this country. And this constitution needs to be respected. There are legislation that regulates them, which is the powers, privilege, and immunities of Parliament and Provincial Legislatures Act. Is subservient to the constitution of this country. And it follows that whatever they do should be in line with the constitution of this country. So it's very clear that the constitution of this country is a supreme law of the country. Any act that is contravening the constitution is unlawful. That's what the law is saying, very clear. Now, the appeal is very clear. We don't want to talk about it. It's sub judice. But we want to make this very clear to say the ad hoc committee appears to have violated the right of Prof. And if they have done that, it means they have violated his constitutional rights. And his constitutional rights are as follows. One, we have raised issues that relates to section 39 of the 34 of the Constitution, which is very clear to say the type of fora that needs to be able to assist in them having to regulate this inquiry must be regulated by an independent, impartial, and fair type of fora. And the reason being, that fora is going to do an adjudicative role, not a legislative role, but an adjudicative role that needs to make a recommendation and findings. And when we talk recommendations and findings, it means it affects the lives of people. Now, our argument has always been, if that is the case, natural justice must prevail. Section 34 should be the order of the day. They have to be able to ensure that there is fairness in the process, there is impartial in the process, and the structure must be seen to be independent. So that has not happened, because we're talking to politicians there that have party lines. Of course, we cannot tell them what to do, but our view was solely based on the constitution of this country. But it goes further than saying that his constitutional rights in terms of section 9.3 of the Constitution is very clear also in terms of the discrimination that appears to have happened on the grounds of his disability. Remember, he is partially blind, and the Constitution is very clear in terms of how must he be treated in terms of this type of forums. He made it quite clear to say, I need to have statements that will be accessible to me as a partially blind person. I need my lawyers to be able to also have the documents that will be able to assist for me to be able to can advise them further as to how to go about these matters. And he hasn't got that. And that is in violation of this section, that is section 9.3, that says if it's not happening in that fashion, then it means they have discriminated on the basis of his disability. So that's also a point that needs to be discussed. And we have raised some of these things in letters that we have interacted with them, and we're still waiting for them. For instance, when we expect him to go there, you need to ensure that he has the documents in Braille, for instance. He is the person that needs to advise us and what to do in terms of the law. And we will be able to also brief him, but he has to go through the documents, for instance, for him to be able to have a sense of what is happening. And that has also not happened because his right has been violated. I would not want to go into the issue why, but the third issue that we think is also important is really the issue of the United Nations Convention on Persons with Disability. It's very clear that we are signatories of that convention. And we expect that the state, which is South Africa, should have also applied and complied with that particular convention. And it hasn't happened because they are very clear to say what must happen in terms of that particular convention. And it says that the state party shall take measures to provide access to people with disability. Now, here we're talking globally. And here the people who are supposed to have ensured that the Constitution is protected and promoted are the very same people that are now in violation of this very same Constitution and the conventions outside this country. And on the basis of that, having said also by a number of people, there is no way we as lawyers can be able to say, no, everything is fine. We must not be able to then ensure that we protect and defend his right as a person. And we continuously will do that because we have been given the mandate, the instruction to say we must be able to continue with the issues of the right. But suffice to say, we were really disappointed because our intention was to participate in this process. All what we wanted was to just brief them in terms of our approach, to say this is our approach. But what we saw there is really a serious concern to say, are these the people that we have voted in as members of parliament treating people in this fashion? And we can make a number of examples of that. For instance, they have quite clearly said, no, Prof must be dismissed. This is a committee that Prof must go to be able to also prove that indeed whatever he said, it has not happened. He must be able to prove his case. But how do you do that if we are not even going to be given an opportunity to raise issues and cross-question any witness that we feel that might not be able to tell you the truth? So how do you sit there as a lawyer together with Prof and say, no, they can be able to continue? And Prof has advised us quite clear to say, if that is the case, I am instructing you to say, I cannot sit in such a process that disregards my rights. And we must be also make it clear to say, we don't think there's a problem with what Prof has done, because his rights has clearly been disregarded by people who are supposed to assist us to promote these rights, and it has not happened. So we have the instruction that is very clear to say we are going to continue with ensuring that we protect and defend the rights of Prof as our client. It's very clear. We're not going to run away from that. We are making it quite clear here to say ours is not in terms of what is happening outside. We focus on the Constitution, we focus on the right of Prof, and we have the instruction to do that, and we will continue to do that. Thank you.
Good afternoon, colleagues. I think for me, there's only one issue to deal with, and that issue relates to the question whether or not the SABC has got the authority or is able to instruct attorneys in light of the fact that we currently have a board that is not correct. I think it is important to note that the SABC, in as much as it has a board, but the day-to-day runnings of the organizations are not managed by the board. We have what we call a group executive committee, which is responsible for the day-to-day running of the organization. And how this works is that the Broadcasting Act gives the management of the board, of the SABC to the board. And then the board, through a document that is called the Delegation of Authority Frameworks, delegates its authority to run the SABC to the group executive. And then this delegation of authority framework then tells you how certain decisions should be made and how certain, at what level those decisions should be made. For instance, a decision to appoint a law firm or to defend or take action for the SABC is not merely taken by the board, but it depends on a number of issues. Firstly, it depends on the value of the action. It depends also on the type of action that is involved. Last week, one of the questions that were raised was whether or not the SABC had the authority to be in court in order to be party to the application that was in court. I can confirm now that in terms of our delegation of authority framework, which we had considered even before we went to court as the legal department, we went through the delegation of authority framework. We made sure that even before we instruct attorneys to get involved or to participate in that particular action, we get the proper authorization for the SABC to participate in court. So I just want to reassure people that at any stage when the SABC goes to court, even during this time when, which I normally refer to as our trying times, because we do not have a board that is correct, we will never go to court unless we are duly authorized to do so. That is all that I wanted to address. Thank you.
All right. So, members of the media, colleagues, the panel now turns the chance over to you to address them. Questions, we are ready to take your questions now. By show of hands, please, colleagues. First, Monique. Okay, let's take those three in the meantime. Please indicate, colleagues, state to who your question is directed.
Yes, it is from Business Day. My question is directed at Prof Maghuve's lawyer. In terms of what happens between now, I mean, the inquiry is proceeding as we speak. I think they're sitting until next week, Thursday. I'm not quite sure when Prof Maghuve was meant to appear. Does it mean he's not going to attend at all? My other question is the appeal. You said it's sub judice. Just want to find out on what grounds are you appealing before reasons have been given? I don't know if you can sort of like explain the process behind that. My other question is directed at the CEO, James Akuna. What other documents? I know there's an issue around the multi-choice document. What other documents does the committee want, which you feel are sensitive at this stage? Yeah, and also the ANC in Parliament, they've just released a statement saying your actions were quite disrespectful, that you walked out during the committee meeting, and that you could be liable to a fine or even imprisonment. If you can respond to that.
Thank you. Will you next?
Thank you very much. We are Green from SABC. Well, the other question I wanted to pose relates to appeal. It's been posed by my colleague. I'll read that one. But just want to ask the question of non-disclosure of some of these documents. It seems that the Parliament is relying on a certain legal instruments, the Powers and Privileges Act, which empowers them to subpoena people and disclose those documents. Also, I think they also rely on Section 32 of the Constitution, which gives people a right to access of information that is held by a state or an organ of state, which SABC is one of that, Empire, Promotion of Access to Information Act. Now, it seems to me that SABC is saying that you can't disclose these documents because of commercial reasons. Do you think that those reasons trump those constitutional rights that I've referred to, Section 32 of the Constitution, higher, as well as the Powers and Privileges Act, which Parliament has relied upon?
Monique Mortlock of IOTS News.
My colleague over there asked the question already. That's fine.
Okay. I'm still McKinnon.
I'm still McKinnon from City Press. My question is also linked to the documents that have not been handed over. I mean, there is, firstly, you were in court on Friday and you argued against releasing these documents. The court dismissed that case. So are you not in contempt of court? But also, Parliament has made a provision for in-camera hearings, sensitive witnesses and so on. So obviously, if you stated your case to Parliament, they surely would agree if there is sensitive information in these documents that can be aired publicly. So why are you so, not keen against releasing them, if there are such options? And my question to Professor Maghuve, and I'm in no way suggesting that you say you should resign, but why have you not resigned? You obviously the only non-executive remaining. You don't correct, you can't have certain meetings, and I understand there are certain committees within the board. With yourself there, I mean, how does it help anyone or anything being the only member there?
Okay. Can I just
go ahead.
Just to add on to my colleague's question, I actually wanted to ask what is the end game? I know your lawyer, Mr. Masu, sort of alluded to the fact that an ideal scenario would be the SABC board members that resigned be replaced. Is that still sort of what you're holding out for? Just to add.
The panel will respond to those questions.
Yeah. Maybe let me start. With regard to the issue of whether Prof is going to appear or not to appear henceforth, we have indicated quite clear and as instructed by Prof that Prof is not willing to appear before an ad hoc committee, firstly that is poisoned and conflicted and disrespect his rights. And it's very clear that for as long as that committee is constituted as it is currently, there is no way that Prof will be able to add value because they have already taken a decision to dissolve the board. So there is no need for him to go there and be ridiculed for something that he knows already they have taken a decision. So Prof admitted quite clear to say, I do not have the appetite to go there because of what has happened, but also because of what we have raised. But coming to the issue of the appeal, of course, you ought to know that on Friday, we had this agent application that has been dismissed, of course, and we strongly feel that the judge has in terms of the decision that he took, though we're still waiting for the reasons, but it was quite clear, that the judge, there are a number of things that the judge have really not considered. Because if the judge has considered those things, then the judge could not have come to this conclusion of dismissing it. So on the strength of the dismissal, we discussed that with Prof, and Prof then felt that because there was these things that are not clear, especially his constitutional rights, let us be able to take up this matter so that this matter must be ventilated, not only for him, but for all those who are coming before him, because it's quite clear in terms of Section 34 of the Constitution that this type of structure will create some problems. So that is where we are. In relation to moving forward, of course, we're still engaging, and Prof will further advise, but already Prof has the view of saying we must continue. Thank you.
I'll deal with the issue of the documents. I just need to put clear, there are a couple of documents that they have asked for, but some of the requests were not very clear. For example, they said they needed documents on the appointment of the Group Executive Corporate Affairs. And we're saying, but he wasn't appointed. He just reverted to the position. So he reverted to the position. He was formerly COO until a court case in the Supreme Court of Appeals set aside his appointment, and we're very clear, we said it was just a decision of the executive directors, which the MOI empowers us to do. So it's not that there's a ream of documents coming in that we need to present. So those are sort of the kind of documents that we are talking about, that there are no documents for that because it's just a decision of the executive directors. Another one that I would give you an example of that they have asked for are management reports. And they said a management report showing the SABC's, what I would call probably responses to the AG's findings. And for me, I would call it an action plan to deal with the AG's findings. Let me just clarify this issue. I'm an auditor, or was an auditor, quite experienced auditor. When you go and do an audit, you assess internal controls and you do a couple of tests here and there to give you assurance that certain disclosures are fairly stated or not. And you can come up with a fake document of that kind. But the auditor also decides whether those amounts or those findings are material enough to affect the fair presentation of financial statements. And we're saying that from 2013, we had management letters, and contained in those management letters were material misstatements or a culmination of a lot of activities that led to material misstatements in the financial statements. And as a result, we had 9 qualification paragraphs. But their nature, their significance, led to a disclaimer of the financial statements. We put in place an action plan. And I always use 2013 because that is when I joined the SABC. And I will tell you, so under the chairmanship of the board, the chairperson here was part of that, I think it was an interim board that actually drove that action plan. I wrote it. And we dealt with all these issues simultaneously, every year. We're sitting with one qualification paragraph that arises from the misstatement of irregular, fruitless, and wasteful expenditure. And I don't want to go into the detail, but the issue here colleagues, is that we're dealing with an organization that incurred this expenditure historically. The note is about historical stuff up to the current year. So when you have that kind of expenditure, it talks about systemic issues that you need to deal. So we are dealing with historical issues and also dealing with systems to give credibility to through that note. It's a very, very tedious manual exercise. So it's a question of time that we will sort out that issue. Now, my point is, there's no resistance in sharing a management letter. It's not normal that a management letter is shared with any committee. I sat at the AG for 8 years as a senior audit manager. There's no committee where we brought a management letter. But if this one is desirous, wants to get the management letter, it may get it. But I'm saying, if you have one material qualification, just one qualification in the financial statements or the auditor's report, and the committee wants to get the management letter, to what end? What is it going to really serve? Because I can tell you, in my experience as an auditor, especially in the public sector, there are certain entities where I would have 600-page management letter, but they're mostly administrative matters, or they cumulatively they're not material enough to lead to a qualification. So we're saying, is there something unique with the SABC that it has one qualification and you want to have that? If they want it, it's something we can give. But we're saying that included in some of those in management letter findings, you may find there's certain sensitive information that we don't want. Because when you audit a set of financial statements, you audit the balance sheet, income statement, and so on. And we say, for example, if they go and audit a deal there, and then they disclose certain things, is that information we want to share? I'm not too comfortable with it because it's not something that I'm very used to. There are certain issues also that you have said, are there any other documents that they would want to? You actually tell me indirectly, but there are certain issues in the management letter that we need to deal with internally. And the challenge I have here as an ex-auditor is that these documents are written by financially trained people, and they're going to be ventilated in the public. And I'm just trying to say, isn't there a possibility that the contents of that management letter will be misconstrued? And I'll give you one example. In 2014, when the Auditor General raised the qualification on the accuracy of the TV license revenue. In short, what he was saying is that the disclosure of TV license revenue was not complying with the standards of revenue. And the reason for that is that the SABC was not accounting for TV licenses that should have been paid, but we hadn't received cash. Debtors, what you call debtors, or receivables, if you want to use the word. What did you, colleagues in the media, go and say? Everything else other than what the AG said. You know, all sensational things. The SABC is wasting TV licenses and all sorts of things. But what the AG was actually saying is that if you expected 100 rands in TV license revenue in the year, that should have been your revenue, irrespective of whether you collected 70 rands in cash. So your revenue should have been 100, 70 in the bank, 30 as a receivable or a debtor owing to the SABC. Now, because of that qualification, the media headlines went to town. They took us to town. I see even the interpretation of the irregular, fruitless, and wasteful note. People say SABC has blown billions because of irregular expenditure. And we're saying no, it does not necessarily mean that if something is being acquired by not following the process, therefore it becomes irregular, that the services or goods were not received. They could have been received, and there could be a suspicion around, the process, which could have undertones of fraud and corruption, probably. But doesn't mean the services were not received. So we're saying that this letter, on its own, it's not normal that it gets ventilated in public space. But they can receive it. But there are also contents in that management letter of things that would not want to be in the public space because they involve the operations of the SABC at any point. But I cannot tell you now what it is. Would have liked that opportunity where the attorney of the rather senior counsel representing the chairperson wanted to address the committee, and he wasn't given that chance. I think the chairperson has talked about. Those are sort of issues we wanted to discuss. That is their way we could discuss some of these issues out of the committee. But unfortunately, as they have already said, we were not given the opportunity. You've talked about the ANC statement, a fine imprisonment. I haven't seen that statement. I'm not a lawyer. My legal colleagues, when they read it, will advise us. But I note what you're saying. I don't know whether it's true. I haven't read it. I have no comment. Thank you.
But maybe just to emphasize what the GCO is saying, if you have checked the proceedings, not all members, they were vocal on the matters. I think some of the members, because we should not generalize issues, we are also saying some of them, they have already prejudged the SABC. If you have already prejudged the SABC, we are saying you should remove yourself because you are conflicted already. If you have given a statement about the organization or the chairperson of the board, you have already a certain view, you have concluded. So that board is not independent anymore. And we are not saying all members are conflicted in that space, but we are saying some of them. You as journalists, you'll know who said what publicly, so it is not a secret. We are saying those people are conflicted, they are not fit to hold the inquiry. But we are still willing to cooperate and defend the organization and not be apologetic on making sure that we assist our own people. If it is a sin to empower Africans, it's a different ball game. And for us, we'll die for that. We will defend anywhere when it comes to making sure that we do what we are supposed to do by the Constitution. But we respect that committee as long as, actually, in my personal view, some of them, they need to remove themselves. A new body should carry on because we want to give the facts. But we are just concerned about people who have already prejudged the chairperson or the SABC. And I want to allude that there is no chairperson that side and SABC that side. We are all in one pot. And we are all defending organization because the chairperson is still the chairperson of the board. And you are also aware that there is a Companies Act. And Companies Act is clear. And you as journalists, you need to read more and more. That as long as you have directors, because James is also a board member, you also have other two board members. They are board members. They are registered at CIPRO as board members. There is a board at SABC. In this case, we are using Companies Act to deal with all these issues that you have been alluding to. You wish that the chairperson should resign, but the chairperson should stand for the truth and defend the truth. Because if we can't deal with these issues, every board at the SABC is going to be collapsed. And it has been collapsing, not today, not yesterday. You know it is a history at the SABC, that as long as we as SABC, we can't deal with the real issues. And the ad hoc committee, in their credit, to try to look for information and deal with the issues. But what we are saying, we are willing, as long as there is fairness in that process, where we can assist the committee so that we don't have all these issues about the board being dissolved every time, because immediately when you do that, you also affect the financials of the organization, because all people, they want to invest where there is stability within the organization. We want this inquiry. We want to face it, but we have a concern about people who prejudge the organization.
Yeah, maybe just
let me respond. The issue of when am I resigning? My response is as follows. In 2013, I got an appointment letter from the appointing authority that I must serve on the SABC board. To date, I haven't received any letter from the appointing authority that says my service is terminated. If the appointing authority no longer needs my service, I'm sure the letter will be coming from that appointing authority to me to say, I'm terminating your service. I don't see why I should resign. I've never appointed myself. I'm waiting for the letter from the appointing authority to say, you have worked thus far. Can you please step down? The other issue that I also wanted to point out is that what Mr. Mutshweni have said is true. Since the advent of democracy, I can't remember a board that has served its full term. And now the question is, are all these men and women unfit? This is the question that we should leave to the public. Something is wrong. And I believe that this needs to be corrected, because there will be no board that will serve its full term. Thank you.
Yeah, thank you very much. I think I left out a question that is very critical, that is very important. When I was saying that the powers, privilege, and immunities of Parliament and Provincial Legislatures Act is subservient to the Constitution. In other words, what I mean is that this act is emanating from the Constitution. And the reason why I raised that was saying that on the 3rd of November, you would know that the National Assembly met and they appointed this ad hoc committee. And of course, they appointed it in line with this act that I've just mentioned. And now, when they appointed the committee, it was a legislative responsibility, which is quite correct because that's their responsibility. But they appointed this ad hoc committee to do to do work that needs adjudication, and when you do adjudication, you cannot remain a legislative structure or body anymore. You need to be able to do that work in a manner that is independent, fair, and impartial. Now, what it means in essence is that this committee was appointed to do work that needs to come up with findings, as I already said. Now, these findings are going to go to Parliament, of course, for them to discuss these findings and resolve to say this is what we are going to do. But these findings should emanate from a process that has been fair and impartial. Now, if this committee is as it is currently, when they take decisions based on voting, it cannot be fair. I think all of us agree on that it will not be able to have the fairness that is needed because it will be based on the political likeness of a particular position. Now, hence we're saying that perhaps at some point we need to take this matter to the Constitutional Court so that the Constitutional Court should decide on this matter to say, is it correct for Parliament in terms of this act to appoint an adjunct committee out of politicians to do an adjudicative work? That is very clear a constitutional issue that needs to be ventilated even at the level of the Constitutional Court. But currently as it stands, we feel that this matter needs to be ventilated by the courts that we have taken this matter to, because you cannot have that structure and expect fairness. There is no way that you will get fairness from that structure. So that's why I was saying this act is really an act that needs to be able to be in line or comply with the constitution of the country, because all of us agree that the constitution of the country is a supreme court, supreme law of the country, and any legislation should be able to fall in line with what its aspirations are, and it cannot be vice versa. So I just wanted to clarify that.
Maybe City Press, just you asked an important issue about multi-choice. We are not dealing with multi-choice only, or South Africans, big companies. Also in our partnership, we also have international relationship with other partners where we do international business with them, but really partnering with international organizations. So these are very critical issues for the organization. It's not about multi-choice. There are many contracts within the organization. It's just that people are focusing on multi-choice. But also, multi-choice, if you remember, we have been repeating this. Multi-choice, all your 404 channel is not a multi-choice channel. It is an SABC channel. It is piloting there in that bouquet of multi-choice. During migration, so that SABC, when we move, at least we have 2 or 3 channels. But if we don't have those channels, even if you migrate, we are going to have 3 channels. So the reason why we have those channels there is part of digital migration. So people need to understand that. But we do have business with international partners that we deal with. And actually, I want to emphasize, the risk here is, SABC, we can release documents today. So here are the documents. But I can tell you, the most people who are investing at the SABC, they withdraw. SABC collapsed financially. It can't pay its own employees within the organization. It can't put content on air. You can't even watch news. It's a reality. I think people need to be very sensitive when we deal with these issues. We are not refusing, like people thinking that, hey, what is happening? What they're hiding? Why should we hide? We're not hiding anything. What we are hiding there is that confidentiality within the partners, because when we sign those clauses, there is agreement between us. And remember, we also compete with other broadcasters. If we leave print media aside, other broadcasters where we are saying this is relationship between you and us, and these are the conditions amongst the broadcasters or other partners. So we don't want to really reveal all those information. But if the information is secured, if we can have that evidence that someone will be arrested if you release that information because you'll collapse the organization, we will be willing to share information with people who will be able to guard against that information and protect the workers and public generally. Because if you switch on the SABC, it's blackout. So that is very important. People just need to consider that. We are not saying, no, we can't reveal information. Example, why can't you reveal 9010? What will be the problem? Because 9010 is part of empowering our own people. give documents. There we don't have any problem. We have our editorial policy is there in the public. You can go and read. I mean, we arrived to that decision by making sure that we take public interest first. But also remember, we changed the procurement process so that SABC is flexible to compete with other media house or other competition.
Okay, colleagues, further questions? And this is where Mbulaheni Maghuve. That order, please.
3 questions of clarity. Mr. Lieutenant, you said there is a board at the SABC, and you said you are using the Companies Act to come to that conclusion. Did I hear you correctly? Are you saying there's a functioning correcting board at the SABC as we speak? Is that what you're saying? And to Mr. Tekisho, I just want to, oh no, I just went blank. I just wanted, because now you went back to saying the committee is poisoned and so on. We're back at square one. It's like you never went to court on Friday. Is that where you are at the moment? And also, I'm not clear whether you have filed the papers at the court. Have you gone to the court already to say we are appealing? Appealing what? If the judge hasn't given you the reasons for the dismissal, what exactly are you saying to the court? Thanks.
Also, questions of clarity. 2 questions on the decision not to attend inquiry. Are you not running the risk then of being found of being in contempt of Parliament? Because from my understanding, from what MPs were saying, they were that legally Prof Mbulaheni has to appear. And then the other issue of the appeal. I'm not a lawyer, obviously, but I just need to understand. Were you not first supposed to obtain an interview to stop Parliament from proceeding with its work? And then, pending sort of like your application to appeal being heard, I'd assume that should have been the process. So I think that's why right now Parliament is proceeding with its work. Then the other issue from what you were saying was that effectively you're challenging what the Broadcasting Act is saying, because the Broadcasting Act specifically says that a board can be dissolved or after due inquiry by Parliament. That's my understanding. So we're challenging that clause, a particular clause of the Broadcasting Act.
Is there a follow-up question to what you've already asked?
Yeah, it's just another question of clarity. Because you keep saying we respect the committee, we respect the process. On one hand, it's poison, it's a kangaroo court. What are you saying? Are you walking out from that process? Or if you are going back on what grounds? So if I report what you are saying, has the SABC pulled out of the Parliamentary inquiry, can we get clarity on that?
Yes, my question to the lawyers, I think it has not been answered. I posed a direct question, and quite right, the powers, privileges, and immunities act is subsidiary to the Constitution. But I asked the question, isn't the SABC bound by Section 32 of the Constitution, which says anyone has got a right to the information that is held by the state for the exercise of their right? So the question is, by not disclosing some of these documents, is it the SABC in violation of that constitutional right in Section 32?
Yeah, thank you very much. I think I'll be assisted by my colleague this side. I would want to deal with the issue of poison. The ad hoc committee. I'm saying that because we have made it quite clear that indeed this process has been conflicted. There are members that have prejudged already the type of action that is going to be taken by this committee. So it's very clear to say it's just almost like to say it's a waste of time to go there, because people have already decided to say what is that they are going to do with regard to this board. But let me come to the issue of the appeal. Yes, we have filed the appeal. It's quite clear. That's why in the morning the chairperson made it quite clear to say there's an appeal, and they went to go and discuss and came out to say there was a legal advice that is very clear to say no, yes, they can continue. However, the advice is to say when they continue, there is a possibility that when the appeal continues, and assuming that we win, all what they would have done will be null and void. So that was the advice. So the issue of the dismissal of our agent application, yes, is there. We haven't got reasons, but it doesn't take away the right of Prof to be able to appeal timeously. So we were there, we have seen issues, we have heard them, and we, on the basis of those issues, we then appeal, but subject to us having to amend whatever will make us to amend when we've got the reasons. But it doesn't mean that you cannot appeal when you are still waiting for the reasons. You can still appeal, it's a notice, and then as you get the reasons, you will just be able to then augment and be able to ensure that all the issues that has been raised, you can be able to correct in terms of your appeal. So it's possible that you can appeal. Now running the risk, yes, there is a possibility that they may want to go to court in terms of contempt. But of course, we feel that we have very good reasons to do that. We have made it quite clear to say, give us an opportunity to also give you our view in relation to the process. And they have denied us that opportunity. So what more do we have to see there in a almost like kangaroo court, listening to people that have very serious problems with you, but not giving you an opportunity to be able to revamp some of those issues that are there that you can't even raise. So what will make you to sit in such a type of committee? Because it's not giving you any right to be able to revert what is said, but also you can't ask questions, you are not given documents, but you are there. So our advice was quite clear after we have discussed to say, is there any reason for you to sit? And Prof gave us an instruction to say, no, after this is what we are saying and this is what must happen. Remember, we must get instructions from Prof. We cannot decide that on our own. And after we have briefed Prof decided otherwise, and we have to implement as lawyers.
I think
before Mr. Vilakazi comes in, I want to take you back to what I've said. The committee, the chairperson in his letter to me, he said, I'm entitled to certain things. I'm entitled to documents, I don't have them. I'm entitled to witness statements, I don't have them. I'm entitled to legal representation when they want to raise concerns, they're not given an opportunity. I'm entitled to cross-examining witnesses. That too, yesterday, was made clear by the chairperson that it will not happen. So, what am I there for? Just to listen to people talking bad about the board and about myself? Maybe you media people, you should also help me. Witnesses will be making serious allegations, and I'm not afforded the opportunity to cross-examine them. So if we talk about fairness, is that fairness? Really, it can't be fairness if what was promised to me has been now been taken away. Almost all of the things that were promised to me are taken away. So I'm there to be embarrassed and not to defend myself. It can't be fair. really it can't be fair. I also need to engage those statements so that then I consult my legal team as to which position do we take. But I don't have them as we speak. And the process has started. Do you think that I will get them tonight? If I get them tonight, when will I be able to prepare myself and to engage those documents that I'm referring to? When we talk about rights, it can be rights to some and not to all of us. I'm not hiding anything. I'm not unnecessarily becoming stubborn, as some people think. I'm not rude, and I'm not disrespectful, because you see, with members of the ad hoc committee, once you raise these issues, which you are entitled to, that is interpreted as being rude, as being stubborn, as being disrespectful. But really, I cannot work without documents. And it is the duty of the ad hoc committee to provide me with those documents. And I think because this is their exercise, they should also bear those costs, not SABC. Thank you.
Okay, I think I would like to address two questions. The first one relates to Section 15 of the Broadcasting Act. I think one of our colleagues asked if the action that was taken today or walking out of court is not, of Parliament, is not working against, is there a problem with that? Okay, is not working against Section 15. My understanding of the section is that it is aimed at assisting the appointing authority to make a decision on whether or not to dissolve a board. And you will notice that in the section they are saying after a due process. A due process means it will be a process where people that are participating in are seeing it to be just, fair, and equitable, and it is, according to my understanding, what is at issue here. The chairperson is of the view that that is not what is getting. He doesn't see the process as due for now. He's not against the process, but he's not saying the process is not due. So I'm not going to say whether or not someone is working against the Broadcasting Act, but I will say to you what the Broadcasting Act requires is what is being challenged in as far as the process is concerned. And the second one talks to, I think it was asked by Mr. Green, it talks to access to information. You will see, you will note that our Constitution guarantees this particular right, but it is the national legislation that then puts this particular right into action on how this right must be exercised or anything. You made reference to PI, you made reference to other legislation. That legislation is saying to you, you have right of access to this information which is held by the government or a public institution. But some of the things that are mentioned in those particular pieces of legislations are that those institutions also have a right to withhold the information, for instance, if rights of third parties are in question. So much as there are constitutional rights, those rights still need to be balanced against other rights that are there also in the Constitution. Hence, you will know that our Constitution also talks to the limitation of certain rights. Some rights in the Constitution are not really absolute. Thank you.
Colleagues, we're barely out of time. We also have your punishment deadline to meet, I'm sure. We finally like to thank you. Thanks for bearing with us. Thank you for your patience.
We are not walking away from that. the committee. We're not walking away. What we're saying just fair process. We're not walking away.
Okay.
One of the chairperson of the union said
Well, you're watching SABC News. What you're seeing now is live visuals of a SABC press briefing out of the mother city this afternoon. Now, this briefing, of course, following this morning's walkout from the inquiry by the national broadcaster. Now, the SABC is clearly saying this walkout was prompted by the violation of the board chairperson's, Professor Mbulaheni Maghuve's constitutional rights by the ad hoc committee. The SABC really reiterating that it remains willing to participate in this inquiry as long as it is kept fair, impartial and procedurally correct. Now, earlier we heard from board chairperson Prof Mbulaheni Maghuve. He says he's not against participating in the inquiry, but he does have valid concerns around the alleged bias by portfolio committee, or rather ad hoc committee members. He has always called for this committee to be reconstituted due to his concerns around impartiality. Now, Maghuve says he is legally entitled to documents and legal representation. He says he was not given these documents he needs, and he was told it was available online. Although the committee members had these documents in their possession, Prof Maghuve is visually impaired, and he would of course need these documents and witness statements in Braille for easy use, which are still not with him and his team. He has raised the matter, but he yet does not have those statements, and this has hindered his preparations a great deal. Prof Maghuve is saying he also has a right to cross-examine witnesses, but this is being denied to him. He understands this to mean that the committee has already taken the word of witnesses as truth. He feels his constitutional rights to information in a format that he is able to use is being violated. In the last hour, we also heard from Hlaudi Motsoeneng addressing the media, refuting reports that the national broadcaster is in a state of collapse. We are indeed up and running, as you can see. He reiterates that his 90% content policy empowers Africans across the continent. He warns South Africans to be guarded against politicizing issues like the local content one. Motsoeneng also encourages more sensitivity around the disabled and how they are treated. He says the ad hoc committee should be guarded against being manipulated by those with a vindictive agenda who want the SABC, which is a major national asset, to fail. He warns against vindictiveness against the national broadcaster and misleading media reports. Well, we will bring you more details on that story as they unfold. On that note, let's cross now to some other news.